check. We're just waiting on a quorum, folks. We had a long hearing this morning, so I think people are still feeling that. Give us a few minutes. All right, we're going to bring this second meeting of Judy non-civil to order for the day. You know, we would like to really get things done around here. We're going to rip through some legislation and no negative connotations to that. Beth, I'm going to, excuse me, Representative Moore. I'm going to let you present your bill. I'm just going to make sure that everybody's working off the same bill, House Bill 1426, LC 480584S. Is that what you're working off of? Very good. All right, we'll present your bill and let's dig in.
All right, very good. Well, thank you for having me back. Are there more members online or is it just who's in the room today? Oh, okay, great. Hey, guys. Okay, so I'll kind of, since most of the members then were present for the sub, I'm inclined to kind of skip over some of the key testimony that was provided in that, but if the chairman wants me to kind of start from the top, I can do that.
No, I think, I think everybody understands why the bill's coming. If you just get into the technical issues of what's different about this piece than was about your previous version.
Sure. Okay. So I'll give kind of a truncated version just for the record then. So House Bill 1426 was brought to change the standard of proof that applies to defendants in capital cases where the criminally accused may have a claim of intellectual disability, therefore exempting them from execution. Georgia's current standard in this case is that the accused has to provide evidence that shows intellectual disability beyond a reasonable doubt. That is the standard that's applied. But that is not a proper standard, in my opinion. It was really the function of a drafting error from when the statute was originally created back in 2013. The most widely applied standard in these cases, just not for proving guilt or innocence, but for proving intellectual disability, is preponderance of the evidence. And so what this bill proposes to do is bring Georgia back in line with the national standard, because right now we're an outlier requiring beyond a reasonable doubt for proof of intellectual disability. We're bringing that back in line, just using the preponderance of the evidence standard. So that was the bill that was presented in subcommittee last week. We heard some of the feedback from that committee. I've been working in conjunction with folks on the prosecutor's side to determine what the concerns are. And so what we did with this sub was although I thought the original was pretty brief and efficient in how it approached this problem, we condensed it even further. So in this sub version, we have taken out any mention of a pretrial hearing. That was one of the concerns that some folks on the prosecution side had brought, that they just wanted to jump straight into trial and then determine intellectual disability, after trial. So we got rid of the trifurcation in terms of the procedures on that end. Now the procedure provides in this sub bill that the trial will, first of all, there has to be a pretrial notice of the accused's intention to bring a claim of intellectual disability. So that kind of sets the stage for both sides. The trial will commence, and then at the point of where the jury comes in to deliberate, there is a three-step process. Step number one is the accused guilty or innocent, or is they guilty or not guilty. If the accused is found not guilty, then the trial is over. If they are found guilty, then we will move to step two. Step two is when evidence of intellectual disability is presented to the jury. Of course, the prosecution in that case can provide counter evidence to try to prove that they are not intellectually disabled, but that the jury will be able to determine in step two whether or not the individual is intellectually disabled or not. If they are determined to be intellectually disabled by a preponderance of the evidence at this step, then the instructions to the judge are clear at that point. If the accused is found not to have an intellectual disability, Then we will proceed to step 3, which is the sentencing phase. Of course, the accused can show, additional evidence for mitigation purposes, just as prosecutors can present evidence, can present aggravating circumstances as evidence. But otherwise, what this newly prescribed procedure does is it separates the standards of proof for guilt versus innocence on the one hand, that's still beyond a reasonable doubt, but then changing the standard that's applied to intellectual disability to beyond a reasonable doubt. And that's what's required in order to effectuate the intent of this bill, because right now the current code conflates these two standards, and that's how you ended up with beyond a reasonable doubt as the standard applied to intellectual disability. So we are separating those two standards and then having the jury apply them in those two initial steps, step 1, step 2, as laid out starting in line 22 through 31. And then really the rest of the bill is not so much substantive as it really just, is just a term change. It updates some of the terms that are used. And then what you see in lines 106 to 115 is just a restatement of everything I've described to you. So, ladies and gentlemen of the committee, I truly believe that we have reached, in the spirit of compromise, a bill that achieves not everybody's, but nearly everybody's desired goal, which is to change the standard for intellectual disability, change it to preponderance of the evidence, bring us back in line with the national standard, but doing so in a way that causes the minimal impact on the code for purposes of just making it easy for everybody to adapt to the new standard. So with that, I'm happy to answer any questions. And we know we have some other people that want to speak on the bill as well.
Thank you. Got one question. Representative McLaurin.
Thanks, Mr. Chairman, and sorry I'm late. And I know this is a great bill. I just wanted to ask you, when did you figure out trifurcate was a word? Because I had no idea it was a word until just a moment ago.
I use bifurcate in my normal parlance, so trifurcate's not too far of a stretch, but yes, I agree.
It makes sense that it's a word. I had never seen it before. So congratulations on getting such an interesting word to the bill. But seriously, I mean, this is a really amazing effort, and I'm really happy that we're talking about it. So thanks.
Thank you, Representative McLaurin.
Okay, I don't have a sign-up sheet. Do we have a sign-up sheet?
Nobody signed up.
Nobody signed up to speak? All right, we'll just call you up then. I know you want to talk about it, Jill. Go ahead. Go ahead. We'll have you. You can stay right there, Representative Moore. You want to come up? Introduce yourself to the committee and give us your testimony.
Thank you, Chairman Chet, members of the committee. I think there are some people in the waiting room. I'm not sure.
Or Monday House Meeting Services.
Oh, okay, I understand. My name is Michael Admiran. I'm a senior attorney in the Capital Litigation Unit at the Southern Center for Human Rights. It's good to be back. I know I was here with you last week. I will, like Representative Moore, I'll also try to streamline my remarks a bit because I know I appeared in front of the subcommittee last week. The one thing that I don't think I made clear during my remarks last week that I think informs the background behind the bill is who we're talking about with this bill and why we're treating people with intellectual disabilities differently than we treat other people who were charged with capital crimes. So first, the case law is very clear that intellectual disability is marked by 3 well-defined criteria. This is not people with ADD or schizophrenia or other mental illnesses. This is specifically marked by a sub-average intellectual score, usually an IQ, give or take 75 and below, deficits in a few adaptive areas like self-care and communication, and then critically onset before 18. So if someone doesn't start exhibiting signs until they're 30, they, as a rule, cannot qualify as intellectually disabled under the law. And the reason that the Supreme Court treats those people differently is that they have limitations in communication, they have a diminished capacity to understand and to process information or to learn from experience. They may know right from wrong. They may be competent to stand trial. They may even have some strengths and have the ability to drive a car or obtain a license, but they often act on impulse or under the influence of others. And I think as a class, that just makes them less culpable. And that's why the Supreme Court has said, we have to treat these folks differently. And the court has left it up to the states to define how exactly we determine who should and shouldn't qualify as intellectually disabled. But they've also made clear that some of these outlier rules are likely unconstitutional. So in Florida, or in 2014, it struck down a Florida rule that set a strict cutoff of IQ. In 2015, it struck down a Louisiana practice that made it difficult for people to present evidence of their intellectual disability. In 2017, it struck down a Texas law that unfairly, really wasn't rooted in science or informed by clinical standards. And I think Georgia is that last outlier practice in how we define and determine who is intellectually disabled. And it's unique in two ways. First, it's the only state that makes the ID determination concurrently with the guilt phase determination. And second, it's the only state with a burden of beyond a reasonable doubt. And I think that this latest sub would address both of those outlier practices and would bring Georgia in line with the rest of the country in, first of all, providing for some mechanism for there to be a separate intellectual disability determination. And more broadly, and perhaps more importantly, the standard of proof would fundamentally change and would be preponderance of the evidence, which is the standard that almost every state, with the exception of Florida, has at one point at either pretrial or at trial or both. Every other state with the death penalty uses preponderance. So I'm happy to answer your questions on the bill.
Any questions of the committee? Representative McLaurin.
Thanks, Mr. Chairman. Thanks for your testimony. I'd just like to get a sense of the mechanics of how the evidence would be introduced. I know that, I made a joke a minute ago that we're talking about 3 phases of trial at this point. And I'm used to the idea that there's a penalty phase in a capital case. That's the second phase. So I guess we still have the penalty phase, but it's now third in line, and there would be an ID phase in the middle, is essentially right?
That is right. And actually, in some ways, that's not too different from the way it works now. Because now the prosecution presents evidence concerning the crime. And then there is sort of a mini phase there where the defense presents evidence concerning intellectual disability. It's just that the jury verdict and all the instructions and the evidentiary presentation gets compressed into that first half of the trial. This would, I think, just make it a little easier for jurors and for the litigants and break out those first 2 pieces of the trial, have the guilt phase where the prosecution has the burden beyond a reasonable doubt to prove it. And then a second phase, this is very similar to how Louisiana does it, where the defense would have the burden to prove intellectual disability by a preponderance. And then if the jury says that the person is not intellectually disabled, there would be the ordinary sentencing phase, which wouldn't change and would operate under its own set of rules.
I guess the last question I have, that makes sense, is let's say that I would imagine that there's ID evidence that's relevant to mitigation for the third phase. And would there be any issues at all with raising evidence in the second phase for ID purposes and then sort of using or relying on the same evidence in the third phase? There's no issue with, you'd be allowed to do that, right?
I think you'd be allowed. I think most litigants would probably say, well, if the jury's rejected this, they may point to other reasons as to why somebody shouldn't receive a death sentence. But
so it raises strategy concerns, but ultimately there's not going to be a bar on the use of evidence from phase to phase.
No. Just like the prosecution can use evidence of the crime to justify it.
The aggravators or whatever. Okay, that makes a lot of sense. It seems like a coherent scheme to me, so I appreciate it. Thank you.
Thank you.
No questions online. Thank you for your testimony.
Thank you.
Robert, does Pac want to come up and speak to the bill? Sorry about the sign-up sheet, folks. I think we ran out of paper. There was such a long list in this morning's.
Robert Smith, I'm General Counsel at the Prosecuting Attorney's Council. Usually when people sit up here, they establish their bona fides to explain to you who they are, why they're in front of you, and to explain their base of knowledge. I have not been a trial attorney for 7 years. So my experience with the death penalty is a little dated. I have sat in and prosecuted death penalty cases. I've also been a law clerk for death penalty cases. So I have and worked in the law department with the Attorney General's office and was involved with it that way. So I'm not an expert by any stroke of the imagination on this field. So if I stumble over a concept or I say something inartfully, it's not with intent. It's merely through my own limitations. And part of that also goes to the fact that this bill is on its third or fourth sub now. In fact, I think we've gotten at least 2 today. And I have reached out to the District Attorneys Association. I've asked the 50 members to weigh in on this. And I can tell you that the substitute language we had last week was provided to them, or at least the bare question of not considering the procedure, because if you remember, this bill used to be a procedural bill too. There used to be a long procedural part as well as changing the standard. But we did, Mr. Scandalakis and I did ask the 50 to weigh in on this whole question of, well, if there wasn't a change in the procedure, if there was just a change on the standard, would you oppose or support this bill? And I found out shortly after lunch today, shortly during our break between the morning session and afternoon session, that the DA's Association is still opposed to this bill. So I can tell you that much. But I can't tell you because the substitute hasn't been, they haven't seen the substitute. They've only been asked that narrow question about changing the standard. Because as was just discussed, this does change the procedure. This does make it a trifurcated process. And that's the thing to think about right now, that how it works in one of these kinds of cases, you establish, when you're establishing guilt beyond a reasonable doubt, not guilty, or guilty based on guilty by intellectual disability. Those are the 3 standards. And then based on that, then you go into the penalty phase if it's appropriate. So we're adding a third process in. And I think one of the questions Representative McLaurin asked about being able to use this information, there are no limitations in Georgia as to the kinds of information that a defendant can offer up in a in a death penalty notice case for mitigation. That's fair. That's how it should be. Anything. And there is no standard either. A defendant, juror can make the decision to set the punishment at something other than death for any reason. They don't have to find anything beyond a reasonable doubt to set the punishment at something other than death. If they want to set it at death, then they have to find at least one, if not more, of the noticed aggravating factors beyond a reasonable doubt. That's the only standard. And that's one of the things, the concern, because we are changing the process. This bill suggests to change the process. We're talking, it's easy to talk about the 40. There are currently 40 inmates on death row. 3 of them are exhausted. That means there are 3 defendants who have appealed directly and been denied relief, state habeas and been denied relief. When I say that, I mean not just to the trial court, but also to have been reviewed at all levels, and then federally and been denied relief. And then those, I think it's 3, are simply waiting for a window, a Superior Court judge in the circuit in which they were, or the county in which they were received their sentence and found guilty, to set a date. If you make a change to a process or a standard, those 3 will get new appeals. 5 to 7 years, easy. Plus all the rest. Of the 40, I can tell you that 12 have already raised intellectual disability on some level, either at trial or on appeal, and it's been rejected. And when I say rejected, I'm not talking about just to a trial judge or to a judge. It's been reviewed by the local judge, by the trial judge. It's been reviewed by our Georgia Supreme Court. It's been reviewed in Washington. And know my friend who was just up here talked about Georgia being an outlier, but please don't lose sight of the fact that last week, the Georgia Supreme Court, not Georgia, sorry, the United States Supreme Court, which has struck down Texas and Florida and all the other states, once again reaffirmed Georgia's process, Georgia's standard. If it was so offensive to the constitutional standards, they had their opportunity. I know that a lot of has been discussed about a drafting error that was committed. The statute was drafted in 1988, not 2013. It was 1988. The Peach Page, for those of you who may or may not know what that is, the Georgia State Law Review, Georgia State University School of Law used to do a thing called Peach Pages, which the law review articles are actually on paper that's peach colored, and they discuss legislative histories. A student or author by the name of C. Christie at 5 Georgia State University Law Review 1988, Article 24 discusses the passage of the bill and explains that the language about, back then we used a much more offensive term, mental retardation, was part of the bill that came out of this committee. The former version of this committee was stripped out in the Senate, and then it was added back in. So I will take a little bit of issue that it wasn't a omission, a slight, or a mistake. There was an intentionality that it was done here in the House and then added back in the conference committee, that it wasn't a midnight slip in. And finally, the other thing I want to point out is that we're not just talking about when we change these standards and we're starting to treat people differently, we're talking about treating a murder case where someone has been noticed for death. This process is only going to apply to them. We're not going to apply this process to a murder case that's not noticed. We're not going to apply this process with a standard to someone who is facing arson, aggravated child molestation, burglary. Why do I bring that up? Because there have been 6 or 7, and I apologize for not knowing the exact number, but there have been 6 or 7 defendants who have met the standard of being able to prove intellectual disability beyond a reasonable doubt since 1988. One of them did it in 2013. One of them was a murder case, but there have been other ones as well. So defendants are able to meet the standard. And I can't tell you the number I've asked, but Department of Corrections doesn't keep it right now. So I can't tell you the number of defendants who are housed for charges other than murder and been found guilty and been sentenced to death that are currently serving sentences in our prison system who were found guilty but intellectually disabled. So beyond the 40, I mean, it's easy to talk about the 40, but beyond those 40, I can't begin to tell you the number of those defendants, because nobody knows the answer to that question right now. Corrections hasn't had a chance to do a data dive. But I can't begin to tell you the number of defendants who are facing something other than death, who also would be entitled to a hearing, even if you don't change the standard for them, to make an argument that death is not different, and that if you're going to change the process and the procedure for for a specific version of murder, you should change it for all defendants and treat them all fairly and equally. This is a big bill. I know it's just a few words, but this is a big bill. This is not an easy conversation, and I am not the person who can give you the answers that you may need and may want. This is the kind of thing that, and I do thank Representative Moore. She's been very engaging. She's been very good to talk with and work with, and I have the utmost respect for her. This is and I appreciate that. I really do. This is very easy to take the attitude of this is how it's going to be and not listen to all sides. And this is not a bill that all sides will ever be in agreement on. But this is the kind of bill you start off the conversation in a few weeks and you work on it over the summer with all sides. We're all people, because the Attorney General's office if you don't understand how the death penalty case litigation works, once the district attorney hears back from the Georgia Supreme Court on direct appeal that the sentence and conviction have been affirmed, the district attorney has no more interaction with the case until they get a notice from the parole board that they're doing final clemency review. The attorney general's office, the experts in the law department, are the ones that handle that case and work with the victim from exclusively. We aren't involved, and I can't speak for those experts. I can't speak for those folks. So we need to have them at as part of this conversation as well. That concludes my remarks.
Thank you, Robert. You got two flashing lights here. Representative McLaurin.
Thanks, Mr. Chairman. Thanks as always for your testimony, Mr. Smith. I'll start by noting that I was born in 1988, and I doubt that you think that I'm very old or immune from correction. I guess, it's interesting. You make the remark that this is a big bill. Well, I'll tell you what a bigger bill is, and that's an outright ban that multiple people in here have signed. And if we wanted to, we could try to agenda set that way and go ahead and have that conversation and talk about how when states who have lingering people on death row that they have to find some constitutional way to execute are looking for chemicals and they're trying to source them from all over the world, they're getting cut off by manufacturers and suppliers because the lack of intention to use those chemicals that way on human beings, such that they have to impose policies of secrecy around how they source their chemicals, limit visitors to the actual execution chamber, and sort of hand wave away biological reactions that people on their deathbed are having in response to chemicals that were never produced, manufactured, and intended to be used for that purpose. So we could have a more fulsome conversation on a much bigger scale about that. I see this as a small bite. I see this as sort of an obvious bill to bring us in line with the most basic, not even constitutional Eighth Amendment, to your point, standards of decency. Just sort of a, well, I should say, I don't think it's a close constitutional question on this one. I get that the Supreme Court has not taken the opportunity to weigh in and say, now just a minute on Georgia standard. But I don't think, if we all believe in the doctrine of judicial avoidance and not having to pass on issues, particularly those not raised, I think there's something to be said about being able to argue that this may not be in keeping with evolving standards of decency. So I guess after that little rant, my question for you would be specifically on the subject of the potential for upheaval, because I think that's one of the practical points you're making, is that if we were to adopt this standard, that there would be future litigation involving some existing or outstanding cases. I don't know if I buy your equal protection argument about other murder defendants who don't have death sentences trying to argue that this somehow changes their case. I don't know if I understand that, but at least speaking to folks who are sentenced to death, who would potentially have some viable or renewed ID claim as a result of this legislation. My question for you would be, given the track record when we impose the death penalty of arbitrariness according to race of the defendant, the fact that so many murder defendants, cases I worked on personally, involve people with substantial histories of abuse, trauma, life-altering, mind-altering circumstances that cause them psychologically to be more susceptible to criminal activity than other folks. Given that that's the history and sort of the legacy of how the death penalty is imposed in this country, do you think that it's any sort of accident that a lot of the people potentially on death row in this state or elsewhere have viable ID claims that would only get stronger as the law became more empathetic to the science of how and why people commit crimes? Do you think that that's an accident?
And you see, this is the problem with having me here rather than having someone from the Attorney General's office here. This is the problem with trying to get this bill through so quickly. I think that you asked some very viable questions, some very good questions, and deserve answers. I can't give them to you.
Well, I'm asking you to speak in general because I think you bring to this committee every day a general awareness of the dynamics of prosecution and defense and, criminal law in our courts. And what I'm asking you is, as somebody who I'm sure has experience knowing some of the facts of circumstances of various death penalty cases, which you would agree that you have experience with death penalty cases in general, right? Or are you saying you have none?
I have some, yes.
Okay.
Very limited.
You would agree with me that in general, defendants in these cases tend to be more along the spectrum of having severe psychological difficulties that the average defendant in the average criminal case does not have. Would you agree with that?
No, I would not.
You wouldn't. Okay. Well, and maybe that's just a point of disagreement. But I guess my point today is just, anytime we're talking about the death penalty, it usually the sort of progressive or like woke or whatever you want to call it perspective in the room is trying to have the bigger conversation about the penalty as a whole. Representative Moore has brought sort of a smaller, pragmatic bill, I think, that addresses something that, based on national standards, there's a clear answer to, that not to treat this any differently than other defenses in terms of burden of proof. So I guess what's sort of ironic to me is that, and I get that you're saying that the people who would oppose this may not be in the room, but to the extent you are trying to speak for some of those folks and try to inveigh upon the committee that there's some gravity here that we're missing, I don't see it. I see this as a very reasonable first step towards bringing our laws in line with evolving standards of decency nationwide. And I guess my thought would be that if the DAs and anybody who has, like you say, an oppositional position on the bill want to be involved, there's still time left in this process. And I have not heard an argument yet as to what the principle or the substance of their opposition would be, instead of just maximum flexibility to impose the maximum penalty. Because if that's the only policy justification for opposing the bill, I think you're going to have bipartisan, disregard for that rationale. Anyway, that's it could be a question, but it doesn't have to be. So, Mr. Chairman, I appreciate you letting me speak
Thank you,
with my friend.
Representative McLaurin. Vice Chairman Smith.
Thank you, Mr. Chairman. This has been a very interesting conversation so far, and I'm going to withhold some commentary till a little bit later on how I see this evolving. Ms. Smith, could you give me an example of the intellectual disability that somebody has been successful in preventing having the death penalty sought against them? Because here's the thing, I've been looking for this question. I appreciate the author of the bill talking with me through this. I want to see some hard cases of what this would apply to, because we talk about intellectual disabilities on a spectrum. Well, where at on the spectrum are we going to draw the line? Because this is open season. No pun intended. It is just, to me, if I can understand, what are these intellectual disabilities going to be that prevent someone from having the death penalty sought?
And once again, I don't know. I've got anecdotal research. I've, provided some information, from the brief that was filed in the Young case, the opposition to serve the court granting review, where they talked about the cases that were the defendants who were able to meet the standard. But your question about asking what kinds of examples, I don't know. I truly don't know, because I'm not qualified to be able to do that. To be able to make that finding, you usually have an expert witness who comes in and explains to the jury, but it's still left up to the finder of fact to make that determination. And remember that in Georgia, we have unlimited experts. The defense can bring in as many experts as they want to. Whereas these other states, the 6 states that use clear and convincing evidence, and then the 20 some that use preponderance, each one of them limits it somehow. Whereas the defense only gets 1 expert, or the defense gets an expert, the state gets an expert, and the judge gets an expert. There's much different procedures. It's not, to borrow the phrase, it's not open season. Like here in Georgia, you can have different experts for the guilt innocence phase as you can for the penalty phase. If you go to trifurcation, why not have three different groups? One to handle the guilt innocence phase, one to handle the intellectual disability phase, and then a third group to come in and do that. And remember, and as it should be, if someone is indigent, those costs will be borne by the state, because that's how it should be. We've got to, if we're going to do this, if we're going to keep the death penalty in Georgia, if we're going to hold someone responsible to the ultimate degree, we've got to give them every process and every procedure possible. We've got to be fair. We've got to be right. And if you choose to make the standard a lower standard as a policy decision, that's clearly within your ambit. You can do that. One of the things I'm cautioning you on is what's going to come next. And then the other part is just please get in the people who actually can talk about this beyond a general 1,000-foot view, which is what I have.
Chairman, I actually can answer his question.
All right.
So there was only one case where the death penalty was sought, where the accused was able to prove intellectual disability beyond a reasonable doubt in a jury trial, and that was for the defendant named Vanessa Marshall. There is a distinction, though, that although she did prove beyond a reasonable doubt that she was intellectually disabled, that was a felony murder case. It's a small distinction, but one worth noting when talking about, these kind of buckets of cases, that was not an intentional murder case. It was not a malice murder. It was a felony murder case, but she's the only one, and that case was from 2003.
Vice
Okay.
Chairman Smith.
Thank you, Mr. Chairman. And I appreciate that. What I've been trying to think through on this, what do we do about a situation where if someone, even though they may have an intellectual disability, they have a lucid moment where they clearly recognize what the consequence of their action is? How do we account for that?
I would say that that's where the standard of preponderance of the evidence comes in. That would allow both sides to present evidence in front of the jury. And that's why we impanel juries, is to determine, in this case, what we're hoping for based on a preponderance of the evidence. Does the person have an intellectual disability that under statute, under the Eighth Amendment, under US Supreme Court precedent would exempt them from the death penalty? They can still be found guilty. They can still even receive punishment as high as, life in prison without parole. But the part of the goal here is to acknowledge our constitutional requirement to exempt people who have intellectual disabilities from the death penalty as being cruel and unusual punishment in violation of the Eighth Amendment. And we have an opportunity to do that here and now and make sure that that standard is corrected in Georgia. And I have some more I want to share, but I know we have another person testifying here, so I'll just keep my comment there. But rest assured, we've got more to talk to the committee about with that in that respect.
Very good. Any more questions for Mr. Representative Kendrick's got a question online.
Thank you so much. This question is for Mr. Smith. So we're basing the DA's opposing this legislation. Can you give me some information about this poll? Like, was it a majority of your membership of the DA Association, or is the membership made up of rural versus urban DAs? Because both of my DAs support this bill. So I'm just trying to get at the heart of the information and the makeup of it. And if you could also let me know if you got any feedback specifically from the DAs that did respond back to you about their reasoning for opposing this, or what was that already answered in your previous remarks?
I can try to better explain. Thank you. The DAs Association of Georgia is made up of all 50 DAs. There are 50 judicial circuits. The 159 counties are broken up into 50 circuits. Each one of the 50 circuits has a DA. Each one is a member of the DAs Association. Their president is Brad Rigby, who was here last week. He's the DA from the Cordele Circuit. I asked him last Friday specifically, since he was here and testified previously. And then the question that was put to me to ask him was, find out yes or no as to changing the standard only. Don't talk about process, just talking about the standard. All I know beyond, I asked him that question to find out about the standard. And then I called him this afternoon in preparation to come over here and ask him, one, if he, basically could he share with that? And he told me they're still opposed. I can't tell you anything beyond that. There was no feedback provided to me. There was no discussion about what the voting percentages were, how many voted or anything like that. I can just simply say that the president of the association told me they're still opposed.
Representative Kendrick, did that get to what you wanted?
No, but he doesn't have the information, so that's okay. Thank you.
Thank you.
I apologize for not having a satisfying answer.
It's fine. You don't know what you don't know, right? Vice Chairman Smith.
Thank you, Mr. Chair, for indulging me so much this afternoon. I have to get it out in little snippets. I'm not quite as gifted as Representative McLaurin and getting it all out in each question. So I was reading through here concerning Young versus State. Can someone comment as to the intersectionality of a person's intellectual disability and the facts of the crime? Because to me, and I'm going to read through this whole opinion, but to me, that's interesting commentary there, because it seems like the court was discussing this and how you don't necessarily just divorce the intellectual disability from the facts of the crime, because it seems like maybe the facts of the crime could show that there was an understanding that the accused knew what they were doing. So I'd love to hear what y'all thought about that.
All I can, and it would be kind of insulting to read you back the code, but that's the only thing I would know to say when you ask for what is intellectual disability. That's the only way I can talk about that. I don't have the answer you're asking for.
Okay. Mr. Chairman, could we hear from the Southern Center again? And sorry to put you on the spot in terms of capital litigation. Would it be possible to describe the types of challenges just in general that some of these defendants face? It might be helpful. I don't know if that's something that you
Let's
speak to.
We'll do that. Representative Quorum. Let's. I
Okay.
think there's a couple other folks who want to speak.
That's
to it,
fine. I
too.
just thought it might be helpful to get color from folks who've litigated the cases to talk about like what kind of challenges people have.
Yeah, I'd like to hear that. Thank you, Robert. Jill, are you speaking to the bill?
I'd like to speak to the bill, but I would prefer the answers to come back. The capital litigation, Mike's going to be in a much better position to answer those questions.
Well, can you speak to the reason that there's still procedural changes in the bill? Or should I direct that question elsewhere?
No, good afternoon, Mr. Chairman. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. You can't, when you're changing the burden of proof for a case that's going to go to trial, you have to separate it somehow. The way that the bill as filed separated it was two different ways. It had a pretrial process where a judge would have been making a determination of whether there was an intellectual disability or not. The prosecutors that testified against the bill last week were vehemently opposed to that process, and that was removed from the bill. So then the comments were made, we don't want this extra process. We don't want pretrial, but and I'm paraphrasing here, and I don't mean to put words in other people's mouths, but my understanding was, but we're okay with changing the standard to preponderance when it comes to intellectual disability. I realize that Mr. Smith just said that's not true, but as of last week, that was my understanding, that changing the standard was true. So then you have to say, how are we going to do that?
I'm not going to cut. I don't mean to cut you off, but I need to, because my understanding was that if we were going to move in this arena, approaching anything but the standard was that they were willing to make start a conversation and move forward on that, but go ahead, Jill.
So there's no other state's procedure that considers the question of intellectual disability in the guilt phase of the trial. So when we get to, if we're going to change the standard of proof and intellectual disability, how do we do that? We look at what are done in other states. And the majority of the states do it the way that's been imported into this bill. And that is a determination of guilt, then, which is the prosecutor's burden to prove beyond a reasonable doubt. Then the same jury would hear it and determine whether there's an intellectual disability. And if there is not a showing by the defense, now we're shifting burdens. Remember, we don't want to have one set of advocates with one burden of proof and another with a different burden of proof, and the jury trying to mix it all up in the bowl and come out with answers. So that's why we're doing it in 3 different steps. That's the way that this is set up. The issue of guilty but with an intellectual disability, the only difference between guilty and guilty with an intellectual disability is supposed to be that folks get services in the Department of Corrections for an intellectual disability. I think that, and I think that Mike might be able to shed some more light on this, but intellectual disability is not like an insanity determination. You don't like come in and out of being intellectually disabled. You are either intellectually disabled or you are not. Now, is there some argument as to whether somebody is intellectually disabled? Yes, because, you know, when you're looking at an IQ spectrum and there's a range in there, that's where both sides are going to have some arguments on it. But this, it's not, it's a specific diagnosis, and some people have to be institutionalized and some people can function in society. I know that the prosecutors have set forth like 12 cases that they claim are going to be impacted, that are, death row cases, but there's only we've reviewed that with the lawyers that are involved in those cases, and there are only a small handful of those that we think that actually could be affected.
Yeah, I don't think that's compelling. I believe that if we need to change the standard, we need to change the standard regardless of those numbers. Though I do empathize with the prosecutors and having more cases. The standard is kind of the what I'm trying to get to here. And I think that it is compelling to say that this is a huge policy decision for us, and we've had testimony both ways, for and against. I want to make sure we get this right. We don't mess this up. I don't want to be the chairman of Judy non-civil that somebody's talking about 2 or 3 and 4 and 10 years from now, pushing something through that we're not ready to do. It is also compelling that we have people, actual practitioners. I know we have one side here. So I want to keep working on this. That I believe we can get this thing across the finish line this year. But I need you guys to take out the provisions for procedure. Are you telling me there's no scheme whatsoever where we plug in preponderance versus go ahead.
You have 2 phases of the trial currently. One is guilt innocence and one is the sentencing phase. As you can imagine, in a trial like this, there are going to be elements that are sort of on the range of punishment that come in during the course of the trial, during the guilt innocence trial. For example, whether the aggravating circumstances, the nature of the death. There's also could be mitigating evidence that comes in. Maybe the person is acting under a delusion and is saying, and when they're actually, I'm not talking about ID, I'm talking about insanity. So that's going to come in during the guilt innocence phase. It's also going to be discussed at the sentencing phase. So they're separate. The question you're asking, Mr. Chairman, and in both of those phases, the state has the burden of beyond a reasonable doubt to prove those crimes. And what we're saying, what we're talking about doing is how do we make the standard be actually different for in the intellectual disability, number one, where do we put it in the trial? And how do we separate out that it's now no longer the prosecutor's burden, it's the defense burden to show, and by a preponderance of the evidence, that the individual that's been charged is actually intellectually disabled.
Without tampering with the standard for the prosecutor to prove beyond a reasonable doubt, prove up the crime.
Without the confusion that can be created by putting it in the guilt phase or in the final phase, in the sentencing phase. So I keep calling it the Oreo cookie. It's the cream in the middle to make whether you get to the bottom row of the cookie or not. I don't mean to be unkind when I'm saying that, but that's just what I think. Like the 3-step process is what so many other states are doing. It's not like we've just decided, oh, we'll just pluck this idea out of the thin air. It's being done successfully in many other states, actually unsuccessfully in some other states, because I think Louisiana, who has it this way, has never had anybody been found to be intellectually disabled. So the sky is not falling. There is a way to do this. Obviously, we very much want to get it right. I do think that there's some confusion because I did take some responsibility of the 2013 changes. And just to clarify for the record, while this change was done back in 1988, in 2013, this bill was worked on. This area of the law was worked on when we changed it from mental retardation to intellectual disability. So one could say, why didn't we make these changes then? That's what I was taking responsibility for. Just as a drafter, maybe having raised.
So you're
the
to blame.
I'd be happy to take it, and I'll be happy
No.
to have Ms. Carter take responsibility for the good drafting that's involved in this one.
Chairman, can I speak to your question about the trifurcation as well?
Sure.
I just want to make sure, especially for those who were present for the subcommittee hearing, that at the time there was opposition to the quote trifurcation, but that trifurcation reference was in reference to the inclusion of a pretrial hearing.
Sure.
Right? So that was trifurcation process number one, trifurcation number two, and then the sentencing mitigation was part number three of that triumvirate.
Right.
So even though we're using the same term here, trifurcation, this is a different
Right.
type
There's
of
no
trifurcation.
pretrial. It's all on the
right. Yeah. So it's really
after,
just
finding of guilt.
we consolidated everything. We got rid of the pretrial hearing per the prosecutor's feedback and just made this 3-step process at the point of jury instruction. And we even considered, well, we kind of preempted this question, is there going to be opposition to this now 3-step jury instruction part? But there really is no better way to do it. And if you'll allow me, I'll explain why. It's because the step number one is finding whether the defendant, the accused is guilty or not guilty. And the burden is on the state to prove beyond a reasonable doubt that the person is either guilty or not guilty. If they're not guilty, then the proceedings end. If they're guilty, then we go to step number 2 in the jury instruction process. But at that point, the burden shifts. The burden shifts. It's no longer on the state. The burden shifts now to the defendant. The defendant has to provide evidence for which they provided notice prior to trial beginning that they're going to bring forth evidence to prove intellectual disability. The state will, of course, be able to present counter evidence to that respect. So that second step in this process is important because if the jury finds that there is no intellectual disability, then the person just goes on to the sentencing phase, which might include the death penalty. If they are found in that step number 2 to be intellectually disabled, then the sentencing goes in a different direction. So that's why when I was presenting the sub changes, there has to be some changes to the procedure. There has to be, because we're introducing another step here. Whereas right now, under the current law, that finding of guilt and innocence and intellectual disability are stuck in the same statute. They've been consolidated in a way that applies that beyond a reasonable doubt standard to the finding of intellectual disability. So we're separating those two things And that's why you see that, that three-step process.
Very good. Miss Jill, is that all you had to say?
That's all I had to say. I'm gonna turn it back over to Mike just so that you can hear the answer to
Thank you.
Representative McLaurin's question.
Thank you for letting me back up. Thank you, Representative McLaurin, and Representative Smith. I want to respond to your questions as well, because I think they sort of get at the same issue. So with intellectual disability and crime, I think often the facts of the crime, as the Supreme Court has said, when someone's intellectually disabled, the crime is often impulsive. It's the result of poor planning. Maybe there are others involved. I think in the case that Representative Moore mentioned, that in Vanessa Marshall's case, she was not the trigger person. She wasn't the mastermind. She was, I think, actually quite literally along for the ride, and knew that the crime was happening, knew right from wrong. She was competent to stand trial, and so she should be the jury said she should be punished harshly, but she's intellectually disabled and can't face the death penalty. So I think what the Supreme Court has recognized is that, and this is in a 2015 case, is that with crimes that are so serious and difficult and often horrific, the facts of the crime can overwhelm the fact finder's ability to fairly consider evidence of intellectual disability, and which is often longstanding, relying on expert testimony. And so special care needs to be taken to make sure that whoever is making the decision, whether it's a judge or a jury, they can separate that and give full measure to the evidence of intellectual disability, notwithstanding the facts of the crime. And I think more broadly, thinking about your question about what is the effect of changing the standard, and I want to be really clear, what changing the standard would not do is expand the class of people who are intellectually disabled. We're not saying in Georgia, if you have an IQ of 90 or below, you're intellectually disabled. The issue is that courts have recognized that with this type of determination, beyond a reasonable doubt is an essentially impossible burden to meet. So right now, Jill mentioned our disagreement with the number of people on death row right now who could be affected, but be that as it may, there are people that I'll use an old example, Warren Hill. Every expert from the state and defense who examined him said he was intellectually disabled. He was more than likely intellectually disabled. He almost certainly was intellectually disabled, but even under Georgia statute, he couldn't prove beyond a reasonable doubt. And so the issue with Georgia's law is that right now there could be people on Georgia's death row or facing the death penalty who are more than likely or even almost certainly intellectually disabled, but who aren't meeting that threshold. And that's what the Supreme Court has said you can't do, is unduly restrict the class in that way, where we can feel pretty good, pretty confident that the person's intellectually disabled should receive the benefit of Atkins versus Virginia, and should be sentenced to life in prison. But we're letting them be executed anyway because of this unique standard.
Thank you. Representative McLaurin.
Thanks, Mr. Chairman, and thanks for helpfully clarifying. I mean, I don't want to play scientist because, I'm going to outkick my coverage very quickly, but I do know that there's some correlation between like frontal lobe and impulse control, right? And I can imagine that the less sophisticated somebody is, I guess that's correlated with inability to control impulses. One question that I do have in terms of just another way of thinking about this entire issue in terms of the sort of public policy of the death penalty, the case law, the constitutionality of the death penalty. I mean, one of the overtures I've heard over and over again from advocates who aren't even necessarily abolitionists, but are just saying this is a sort of a outlier penalty, right? It's something you don't get a redo on, right? Once you've executed somebody, there is no going back. the overtures I've heard is, we want to be very sure if we're going to do this, we want to have absolute certainty that everything is lined up in line with prevailing law and moral standards. And so I guess one way I'm thinking about this bill is in terms of being sure, certainty that we're following the law. And to your point, not changing the substantive standards, but just changing the level of certainty required to meet them. Right. To me, it seems like if we have an opportunity to, while still requiring 50.1% or whatever certainty, allow for that flexibility to ensure that we're not executing somebody wrongfully. To me, that's good policy, given the finality of the sentence. And I was wondering if you had any thoughts on that.
Well, I certainly agree. I think that the related point on that is that the Supreme Court recognized that people with intellectual disability face, and I think this is a quote, a special risk of wrongful execution because they're more likely to falsely confess or to acknowledge responsibility that they shouldn't have to bear. And I think in addition to the reasons that Representative McLaurin stated and some of the ones in the Supreme Court case law, that's a reason to make sure that that we don't place on intellectually disabled people the risk of a wrongful execution. Thank you.
Thank you. This is what I want to do. I want to hear this one more time. I want to get the parties together, and I'm telegraphing to the prosecutors that I want to hear this on Wednesday. It'll give us a committee day before sine die for the author to move it through rules, if we can get it out of committee. So I'm committing to you that we'll have another hearing for it. It's just you getting with the parties involved to try and work a deal out here. I think I know. I like what you're trying to do. I want to make sure we don't misstep here. Okay. I appreciate you coming again. And so Wednesday we'll hear this bill again for passage. And I'm hoping that we can get some prosecutors here and talking to the author to see if we can't. I don't want. I understand what you're saying, and the way the statute is written now, that it intertwines the standard with both the guilt and the standard for ID. I gotta believe there's another statutory scheme we can come up without changing the process to a trifurcated process. But I'm going to leave that to you and PAC to figure out. And I would hasten not to include Jill Travis, as she's fantastic at doing what she does. So I appreciate you coming again before the committee. I'm going to hear one more bill because we heard it and didn't. We had a little issue with it, and that's House Bill 1354.
Thank you, Mr. Chairman.
Thank you. Thank you. Representative Holcomb, this is the Compensation Review Panel Bill, House Bill 1354, LC 44-2038S. And as I understand it, you've had conversations with Vice Chairman Smith in regard to the changes that were made on the type of payouts. And so I'll let you elucidate, and then if it's the committee's will, we can move on with the measure.
Okay, thank you, Mr. Chairman, members of the committee. Vice Chairman Smith and I, we attempted to confer with Chairman England, and Vice Chairman Smith and I then had subsequent discussions. I tend to agree with him in terms of the policy, but I'd really like this bill to stay alive. And so we didn't make any changes with it now, but we'll certainly have an open mind as it goes through the process. So this continues to have the changes that were discussed this morning, which would have the annuity requirement and a 25% cash cap as requested.
And just for the the records, this is a process for of which we do not have in place now for
Correct.
paying out for wrongful convictions, a compensation plan. Hold on 1 minute. We just lost the quorum.
Okay. You need that.
We're going to be at ease for a few minutes. We're going to get one more person back on.
No problem.
Late.
At your service.
Thank you for sitting all the way through.
No problem.
Spider-Man. Yeah, it's one way. That's just the first attempt.
Can you get Bodie on?
Yeah. She's, you said until 4:30. Okay. Signal.
Representative Saints for coming back on. This bill's been debated in subcommittee. It's been the full committee once. We had one hang up that has been ironed out with regard to the type of payout. At this minute, it is appropriate time for a motion.
So moved.
Got a move and we got a second for the passage of House Bill 1354, LC 44 2038S. All those in favor signify by saying aye. Aye. Can you unmute yourself and vote yes, please, online?
Aye.
Aye. All right, we got aye and aye. Thank you. All those opposed, like sign, none. Having it's the opinion of the chair, the measure passes on the rules. Thank you. And with that, we're adjourned for the day. We're not coming back in today.